So I would like to start by introducing our panel, and we have people who've been working in the trenches of privacy protection, I guess I would say, and enforcement of privacy protections for years, and it is remarkable, I think, that this field has developed perhaps obviously since 1909, you know, when Brandeis was worried about it, but in the last 15 years, it has become an exciting and invigorating field of law. So let me introduce our panelists. To my immediate right is Laura Berger. She is an attorney with the Federal Trade Commission in both Washington and Northern California. She commutes. She's a graduate of Tulane, where she got her bachelor's degree, and University of Michigan Law School. And she has been at the FTC for a while, and she is primarily in charge with the enforcement of federal privacy regulations, and she's going to tell us a bit about that framework and focus on the cases that she has been involved in and aware of that implicate privacy protection. And to her right is Marcia Hofmann, who is at the Electronic Frontier Foundation, which is another one of our think tanks that focus on the development of the law in these issues. Marcia joins this panel really from a public policy perspective, and one of the things that she does and she will bring to the discussion today is theorize about frameworks, possibilities, dangers, solutions, and she publishes and speaks often about this. She's a graduate of University of Dayton Law School and my alma mater, Mount Holyoke College, which we will say last. Turns out, I think we went to college about 20 years apart, so it's nice for me to be on a panel with somebody who represents that school. And to her far right is Lauren Gelman. Lauren is an attorney in San Francisco. I don't know if it's private practice, but she runs a consulting firm. And her primary obligation, which is fascinating to me, is that she advises companies on how to implement privacy protections, the dangers and possibilities of not implementing best practices. And she, again, because of her position with working with companies both in the city and in Silicon Valley, has her ear to the ground on what some of the major issues are. And overarching all of this, because we do want to think about the ethics of privacy as attorneys work in the field and as the attorneys both in our practices and in our personal lives have to interact with all of the new technology. I think it's going to be interesting, and we're going to stop after each kind of section to discuss the implications for our practice and ways that we can be aware of our professional obligations. One of the things that I learned from attending other panels on ethics and internet and media, social media, is that even though the world of technology is new and changing, many of the rules that applied to our practices when we had typewriters and paper rule books and codes of professional responsibility that we read in books are still in force, even though the world has changed. And what I think about Lauren's company is that she's really talking about the blurry edges, I think, and I hope she will explain that in ways that technology creates a new world forces us to think about new ideas. So without further ado, I should have put their names up here, but please, if you need to see who they are, here they are. And what we're going to try to reach today as we go through the legal framework, we're going to talk about the explosion of new technologies, how it affects what we do. We're going to discuss internet commercial activities from the perspectives both of companies and consumers. We're going to talk again about social media and the internet from both the commercial and personal aspect. And we're going to talk about the effect of data gathering and the potential protections that are available. So the legal framework for enforcement, this is a very brief and generalized legal framework, is both that we have state law, California privacy legislation, and the Federal Trade Commission, and Laura is going to start by explaining their jurisdiction and the framework of the regulations. This is the website, www.privacy.ca.gov, which is the Office of Privacy Protection in the state. And this is the way you get into the FTC website to see what the Federal Trade Commission is involved with. So I'm going to turn this first portion over to Laura Berger of the FTC, and she is going to talk about the federal framework for privacy enforcement.
Good morning. Can everybody hear me okay? Okay, excellent. Well, so I am Laura Berger. I'm a staff attorney in for the Federal Trade Commission, our privacy division. I'm actually based in our San Francisco office, at present the first privacy attorney to practice primarily out of this office, so sometimes referred to as Privacy West. But we do have a team of people working on privacy issues in DC, and I continue to work closely with them, and my colleagues here in our San Francisco office are getting more involved in the privacy type law enforcement and other work that we do as well. So since this is a privacy type panel, I'm going to start with a little bit of information collection from you, and also I'm going to tell you that although the default setting for the panel is a presentation, you have user choice, and you should exercise it to ask questions whenever you want. You don't need to wait. We are obviously, you're my professional peers. You should feel to jump in and redirect me to issues that are of interest to you, or raise any questions that you have. So just so we can all, the panel can all address our remarks to what's most of interest to you guys, we wanted to have a sense. How many of you advise clients on antitrust issues? We know this is the antitrust bar, so we wanted to know. Okay, so a few people. And how many of you advise clients on privacy issues? Excellent, that's a high number.
That's a very high number.
And how many of you are in-house as opposed to, okay, fantastic. And then just for my own purposes, I wanted to know how many folks are familiar with the FTC's law enforcement work in the area of privacy. Okay. And then anybody here familiar with our policy work, like our privacy framework that we put out? Okay, great. Okay, perfect. So, so the first thing that slide that we have up here is just a little overview of our basic law enforcement statute, the Federal Trade Commission Act, Section 5. And because this is an ethics panel, I guess I will frame this for you. I was thinking about how to tie what I do, because I don't practice ethics, but to tie what I do into this ethics theme for today's panel. And I guess one way you can look at this is you can think of this Section 5, this obligation to avoid deception and to avoid unfairness. This is your minimum legal obligation. This is the line beyond which you are subject to possible liability. But obviously, ethics is something more than that. So some of the policy work that we have done that we'll talk about, the framework for protecting personal information, that's to address what you can do, not just to avoid liability, but to do something more, to have best practices. And that can also obviously help you stay on the right side of legal liability. So we'll talk about some of the cases we've had involving deception. Primarily that would be in the privacy context, where a company says something about how they handle users' information, and then they don't live up to it. We've had about 35 cases where, in the data security context, we allege that a company did not live up to its promises about data security. We'll talk about some examples. We've done that in a high number of privacy cases as well, where we said, hey, your privacy setting did not function the way a reasonable user would think it did, or you said you wouldn't share information and yet you have sold it to marketers, or you said you could let users keep information private, but you didn't. This is a nice meshing of the privacy and security. You said you would keep it private, but you didn't sufficiently protect it to uphold that promise. So a hacker got it, and that can also be deception. Unfairness, practices that cause or are likely to cause injury to consumers and the harms aren't outweighed by the benefits. We've done that in a few cases in the privacy context too. One well-known case where we said that a company's wireless transmission of credit card data was not sufficiently protected. So there was no promise there because this involved the behind-the-scenes wireless transmission of data inside of physical stores. This was in the BJ's case. But because they did not secure that magnetic stripe data for the credit cards, we alleged that that was unfair under the FTC Act. So it's a very flexible law. So here are some key actions involving online and mobile apps. W3 Innovations, how many of you do something around kids' privacy? This is one of our COPPA cases, the Children's Online Privacy Protection Act. Well, so basically the bottom line, seeing no hands in response to that, I'm not going to say too much about COPPA. I see one hand. So the bottom line is you have to get parents' verifiable consent before collecting information from kids under 13. If you have, the current rule is if you have actual knowledge you're collecting from kids or if your site is directed to kids. We announced a case on the 4th just recently about Justin Bieber and other celebrity sites which are directed to kids collecting information without following this. So W3 Innovations was our first mobile app case, and it was a COPPA case where there were some apps in the iTunes store that were Emily's Girl World and Emily's Dress Up. You could dress up this cartoon character and comment on her outfit, and through the application, the application developers were collecting information from kids without complying with COPPA. In FrostWire is a remarkable case for the fact that it alleged the default settings of a mobile application to be unfair. It was an application for file sharing, and there are other parts to the case. I'm just giving you the little nugget that hopefully you can take away and have some familiarity with the case. But we alleged that it was unfair to cause users to share more information than they would intend through the default settings of your app. And that's something for app developers and others to keep in mind. You don't want to surprise users, and that speaks to the ethics side of what we're talking about today. You want to live up to what your users would reasonably expect, but it also, obviously in this case, we alleged crossed that legal line. The Google and Facebook cases both were big social networking privacy cases that we brought in the last couple of years. And Google, how many of you remember reading something about that case? You might be familiar with it. Just in a nutshell, so when Google launched a new social networking service called Google Buzz, it took existing Gmail users' data, and among other things, for some of those, it signed the users up to the new social network and revealed information about who their frequent contacts were, which could be very personal. So that was a deception case, but it's interesting to note that we alleged one of the things they did wrong was to render previously private information public, or to share previously private information. And Facebook similarly. Facebook had 8 separate allegations. I actually worked on that case. I'm happy to talk about those in more detail, but among other things, again, we alleged that the company made information more, well, in that case, they did make public information that previously had been subject to privacy settings, and we alleged in that case that that was harmful to users. The Sears case is a good one for you to know. I'm just trying to give you sort of one proposition for each of these cases that you can kind of hold on to as a touchstone for the kinds of things that we've been interested in recent years. The Sears case is going way back to the ancient history of 2009, but most of these are pretty recent, so they're showing you what we're thinking about now in the privacy area in this online and mobile context. But in Sears actually stands for, it's what we call same wine, new bottle. It stands for a very well-known FTC proposition that if you're going to make a disclosure that you need to make for what you're saying to be accurate, that needs to be clear and conspicuous, or you risk being deceptive. So in the Sears case, Sears had done something where they invited users to sign up to be tracked, have their browsing behavior tracked on the internet, and they paid them to do it. Users were paid $10. And so what we alleged was the problem here was that if you read the licensing agreement closely, so if you scroll down to the 7th screen of the window on the end user licensing agreement after you enrolled, you would learn that it wasn't just, what a reasonable user would think is browsing behavior. Instead, it was information, the contents of communication, the contents of your shopping carts, your account numbers, much more detailed than a user would expect. So it really stands for a very basic, something the FTC has done for years in the advertising law context, which is to say if you're going to, if something's important enough that you need to tell the user, you need to make it conspicuous or we can allege deception. So that's the sort of law enforcement background. Any questions before we kind of open it up and move on to, yeah?
In the rear.
Yeah.
I was wondering if there were any cases that deal with those in terms of an adhesion contract or anything.
Right. I mean, I think Sears is actually, your question is an excellent one, and it's a very great segue to some of the privacy framework and policy work that we're going to be discussing. So we'll be focusing on exactly those issues. So saying, hey, to the extent that a company wants to set things up with a user in a way that a user that's maybe, just not oriented towards privacy, is there anything substantive that we can do about that? And we've made policy recommendations in that area. But in terms of law enforcement, I think Sears is a great example of exactly what you're talking about, because the company, from the company's perspective and maybe a lawyer's perspective, people could look at that and say, yeah, it's all in there. You said it. You said what you're doing. And by agreeing to do the tracking program and take your $10, you've agreed to all the terms. But in that case, we said, yeah, that's not good enough. And I know I don't know how many of you have familiarity with some of the class action issues, but I know in the class action context, that can go either way. You may wind up saying, yeah, adhesion contracts will be upheld, but that's at odds with some of what we've said in terms of the kind of disclosures you need to make to comply with the laws we enforce.
I also want to ask Marcia.
Yeah.
Thank you. I can also talk about that a little bit, stepping away for a moment from the consumer protection issues. There is quite a body of case law around that, focusing on the contractual issues. And I think that it's fair to say, as a general matter, that courts have tended to uphold these contracts, regardless of whether you have to actually click a button or whether you simply visit a website and the terms of use of that website says, if you visit this website, you've agreed. There have been a few cases in which courts have found that particular provisions of these types of contracts they're unconscionable, and then the courts will strike those particular provisions, but as a whole, a contract stands up. And that's something that my organization is really struggling with. We think that this is a very problematic area of law at the moment when we're talking about internet-related issues, and it's something that we're very much focused on. And some... Hello. Hi. There have also been some very interesting cases in which both civil litigants and even the government has brought actions against people alleging that by violating website terms of use, their access to protected computers becomes unauthorized for purposes of a law called the Computer Fraud and Abuse Act, which is like the federal hacking statute. And so there's this interesting trend where people are trying to argue that by violating a terms of use, you actually you've become a hacker. And that becomes particularly problematic because there are criminal penalties for violating those kinds of statutes. So that's just something to flag and just to know about.
No, we can move on to this as we continue our conversation, but there's also best practices now. So, some of the more innovative things that people are trying to do in privacy in terms of like just-in-time notice or purpose-driven collection. So ways that companies try to not just not bury notice in the privacy policy, but also bring notice to the time at which the consumer is making the decision about giving up information and making it more real to the consumer in terms of telling them we need this information for the purposes of and explaining the value proposition. So I think that the trend both in enforcement in the law and in practice is away from traditional sort of, bury the bad stuff at the bottom, but to actually bring it really up front and make it part of what the product is to explain what it does. And I think generally you could see a lot of this sort of trend in some of the bigger companies as well, which is, users are finding value in sharing their information for a lot of purposes, so why not just be more upfront about it?
And before we move from the law enforcement part entirely, shift our focus, I wanted to know how many folks work on Fair Credit Reporting Act issues. Anybody? Okay, because the last bullet that's up here, we won't really talk on it, but that was just an example of where we've said if you are doing things to help employers make determinations about hiring, that is a type of decision that's known as an eligibility decision under the FCRA, and you're going to be subject to the FCRA if you're doing that. And these mobile background screeners, we sent them warning letters. They were providing criminal background information to employers and others, and we wanted to make very clear, hey, you're not Experian, you're not Equifax, we know you're not a traditional credit reporting agency, but you're going to be subject to the FCRA when you're selling information for eligibility purposes. So just one little thing for you to know. So this is a great segue from what Lauren was just saying about how, the movement towards in this online environment is to try to make effective disclosures, to try to make your message clear. Companies are doing taking a lot of different steps in this regard. They're doing sort of layered privacy notices so that you have different tabs you can go to, so you're not just looking at a big page that has dense, tiny language on it. There are a lot of things in the mobile context that make this even more challenging. So, to try to communicate with your users about what is happening to their information. And some of those factors are just listed out here. It's a very complex ecosystem. There are a lot of different parties, some of whom are behind the scenes. On a cell phone, you have the device maker, you have the makers of the applications, you have advertisers, you have the carriers, and all these different people can be getting different information about the user's phone activities or their location, their browsing activities, their calling, and things of that nature. And that can be hard to communicate to a user on a small screen. And we certainly recognize that. We've called on mobile providers to do a better job communicating with users and to work together to have better disclosures. But it's something that we're still publicly engaged in. We had a workshop at the end of May to update our guidance on how to make effective online disclosures, a 10-year-old guidance piece we did about online advertising, and there were panels of experts there saying, yeah, there's not really a bright line guidance or tips you can give in the mobile context. So people are still really innovating around this idea of how to disclose some of this complexity effectively. Okay, so next slide. Oh, excellent. No, that's fine. These are just some of the key features that make it really challenging and yet important to do effective disclosures in the mobile context. Next slide, please.
Well, I just want to ask Marcia, on the issue here of the camera, the microphone, the GPS, what has Electronic Frontier been thinking about now these new capabilities?
Oh, wow. This is something we deal with a lot. So I don't know how many of you are familiar with my organization, the Electronic Frontier Foundation. Can I see a show of hands? Okay, a good number of you. So for those of you who aren't familiar, we are a nonprofit law firm and activism group. And we're working to try to make sure that people's rights remain intact online in the future. And so I sometimes say that we're sort of a techno-ACLU, and the ACLU really hates that. But I think that at least gives you a sense of what we do. So this is something that we think about a lot. And it's something that we're actively working on in sort of all areas. GPS in particular kind of pops out at me. Some of you may know that there was a big decision in the Supreme Court in the past few months involving GPS and whether or not law enforcement is required under the Fourth Amendment to get a warrant before tracking somebody with GPS for a prolonged period of time. And the answer from the Supreme Court is that that is a search. And therefore, at some point will require a warrant. The line they didn't draw, I think, well, first of all, what they held was that the actual installation of the GPS is a trespass and therefore requires a warrant. But the question of whether you can track somebody over a prolonged period of time remains mostly open. 5 justices said that they believe at some point that is a search, but they didn't say when. And so I think just when we look at the way that the Supreme Court struggled with that question, we see that judges and the judiciary as a whole, I think, is really kind of struggling with how to deal with these kinds of things. Some of my colleagues, oh, yes?
That involved the triangulation stuff that I didn't think there was a split of decisions among magistrate judges. Was that?
So that was a slightly different issue. You're talking about something that is a huge legal issue right now. Lots and lots of courts are looking at this question.
Sorry, the question.
Sorry
I'm sorry. The question was, what about the triangulation stuff? Is that part of this case?
I'm getting there. So, so the Jones case, United States versus Jones in the Supreme Court, dealt with the installation of a GPS device on a car to track a person's movements over 28 days. Now, there is a whole other series of cases that are dealing with the question of whether law enforcement can collect information from cell phone companies that would tend to show where an individual's location is vis-a-vis cell phone towers. Because you can use the data from various cell phone towers to triangulate the individual's position and figure out where that person is over time. And this is a very interesting issue in light of United States versus Jones because it doesn't require any installation of any device, so there's no trespass. But it does allow law enforcement to track an individual's position over time. And so, as you just correctly noted, there's a circuit split about whether or not that requires a warrant. And there are some there are some legal issues around there also with respect to a law called the Electronic Communications Privacy Act, which is a federal statute that protects individuals' data from being collected by law enforcement from electronic service providers and remote computing service providers. But this is all a little bit sort of attenuated from consumer protection. So if you want to talk about these things, I'm happy to talk more in the Q&A, but I think Lauren has some stuff she'd like to talk about.
Well, I was just going to say how this ends up relating to me in practice, which is that, there are a lot of companies with a lot of data and a lot of people who are interested in accessing that data. So every company has in their privacy policy some sort of statement about when they're turning over information to third parties. One statement has to do with when you'll turn it over pursuant to court access. And this is one of the issues that I deal with companies quite a bit. And the kinds of questions that I ask them are, first of all, going to this triangulation question. It's really just how precise is the data? So you want to have prepared some sort of statement from technological experts within the company that describes how precise the data is, because sometimes someone who's asking for it, once they understand how imprecise it is, they're not interested in it anymore. And then a second thing is, how good a source are you? So it's much easier for law enforcement, for example, to go to entities that they're used to dealing with regularly and get the data from them as opposed to getting it from you. So is your technology producing any additional data that's going to make it a good source for somebody to come ask for it? And law enforcement comes asking for it, but other people in private actions will come asking for data all the time. So, in divorce cases where somebody wants to know where somebody was, or in, partnership disputes when someone wants to know if somebody was using corporate resources for other purposes. So there are a lot of reasons that someone could come asking for the data. And one of the things I try to work with the company is what is the privacy DNA? I mean, are you the kind of company that, you know, for some business reason needs to work closely with law enforcement and you want to be turning things over all the time? My companies I work with generally want to take a more strict position, you know, requiring compliance with whatever legal determinations are made. And this is why things like the Jones case become important in practice, because do you need to ask for a warrant if somebody's coming for location information, or do you need to ask, or can you turn it over under other circumstances? And generally, I put together some sort of law enforcement compliance guide for companies, and you can Google and find tons of these out there from all the major providers. It's not, you know, there's no trade secrets in it, but you know, it's very hard for a company to get a call basically from a cop saying, I need this information, you know, something's happened, can you please help me out? And you know, the impulse really is to be helpful. And, but there are legal restrictions that are in place for good reasons. And if the company has a guide that has, you know, rules and regulations, it's much easier for the person in the company to say, well, here's our guide that explains under what circumstances we turn it over. Even if the guide is just, you know, is like, you know, first thing you should do is call your outside counsel or call your lawyer. And this is frequently the people that you need to be working with on this are people in the customer service department, because a lot of times for a company, the forward-facing contact information for you is to your customer service department, and they might be the people who get the request, and they need to be trained how to deal with that. So, so these are really important issues, and then when it comes into practice for privacy, and you know, and part of this is to go to the ethics question. You know, trying to explain to companies, well, you know, there are a lot of very busy people. Sometimes it's just easy to turn things over, why it's important to make sure that, you know, all the I's are dotted and the T's are crossed, and that you have the documentation that you need in order to demonstrate that you have complied with any requirements that are, any obligations and any legal obligations that you're under.
And just to follow up on that quickly, Lauren is absolutely right that this stuff is very important for you all when you're thinking about counseling companies, because anything that your clients collect is something that could be of interest to law enforcement or to civil litigants and could be requested at some point. And we have something on our website called Best Practices for Online Service Providers, which I would encourage you to take a look at if you find these sorts of issues interesting. And, you know, our guidance is that the best thing that you can do for your users, the people that you collect information about, is to follow a series of guidelines that include things like don't collect information if you don't need it. Don't keep it for longer than you need it. If you don't have it, you can't turn it over. And that makes life easier for you, and often that's better for your users. If you have data for a certain period of time, think about anonymizing it if you still need to keep it. We also have something that we started a couple of years ago, which is an annual report that we call Who Has Your Back, where we've been watching the practices of several of the biggest online service providers and encouraging them to do things like give their users notice when there's been law enforcement requests for their information, so that if they want to challenge that directly, they can do that. We've encouraged these companies to be transparent about the number and types of requests they're getting for user data. We've encouraged them to fight back in court against really egregious requests that just seem ridiculously overbroad. And we've also encouraged them to encourage Congress directly to update some of these outdated laws, like the Electronic Communications Privacy Act, which was passed in 1986 and has never been substantially updated since. And so if that's something that's interesting to you, I encourage you to look at that also. And there have been some companies that have approached us and asked to be added to that list. And if you'd like to do that, feel free to send me a note.
And I would just like to add, I'm a plaintiff's antitrust attorney in San Francisco, frequently involved in complex class cases where we serve broad discovery requests. on defendant corporations, and we have many issues with preservation of email, preservation of company records. And it's very interesting from the plaintiff's perspective. Our position, of course, is not get rid of it as quickly as you can, so you won't be able to turn it over in civil discovery. And the point of all of us, all of our differing perspectives, is that it really is a balance, and it is a balance that both starts being struck from policy issues, but and also reflects from where our practices are and what our positions are at the bar. So I think it's just worth seeing these different perspectives. Okay, now back to Laura Berger.
So I just, if I got up and went to a panel at 8:30 in the morning on a Saturday, I would want some takeaways. So you all have these slides, and you can refer back to them later. But just to synthesize a little bit about what we're saying, I think you're getting a good, clear message here. The things that Lauren and Marcia have been saying about how you need to think about these things ahead of time, and there are resources to help you think about what you're going to do when you get a subpoena so you're prepared for it. And there are practices you can engage in to make sure you know what you're collecting, why you're collecting it, when it's appropriate to get rid of the data. All of these things are a great segue to a key principle that is one of your Saturday morning takeaways, which is called privacy by design. So the FTC put out a privacy framework in March of this year that I've mentioned, and it's a guide for policymakers. It says up on this slide, and the one that you're taking home, I feel bad if this is confusing, it applies to the mobile environment. That was to highlight that, yes, it applies to mobile too, but it applies to everybody on and offline. It's suggestions to policymakers and businesses about how to go that extra mile and really be prepared. So not only are you in a position to comply with the law and explain if a regulator contacts you, yes, we had a plan, and here's why we did what we did, and here are the things we considered. We have a story to tell, and make yourself a much less appealing target for people like me. Privacy by design can do that for you. So we'll talk about privacy by design first, and then we can talk about some of the discussion around simplified choice, which involves do not track, a concept you may all have heard about, and some of the discussion around greater transparency. But the privacy by design is something everybody's really talking about, this principle, all kinds of people providing advice and advocacy groups. So when we did the framework, we made a bunch of observations. I'm not going to go through and list them. I would not want that on my Saturday morning. But just about how the consumer information practices, particularly online, are becoming difficult for users to navigate and exercise meaningful choice about, and have adequate disclosure about. So that was one of the things we wanted to address. And we made very clear, here's one little nugget for you to have to take away. We made very clear, the Commission said that we recognize that in the privacy context, the kinds of harms you might suffer because of a loss of your privacy, it's something more than just, economic loss or physical harm or an unwarranted intrusion. Harm can include, the disclosure of information that was previously private, something that we've sought to pursue in some of our cases. Okay, next. Okay, you can advance through the next couple slides. I mean, the idea of privacy by design, and I think we should all give you guys a chance to talk about it, but is that you should, make privacy the default setting. If you can go to the privacy by design next slide. You should really bake privacy in from the outset, promote it throughout your organizations, make sure you will not succeed at privacy by having a privacy officer who is alone in his or her office. You need to have buy-in and commitment from everybody in your organization. You need to provide them with the kind of tools that Lauren and Marcia are talking about to refer to when something comes up, like, oh, I think I recognize this concept. I think I know that, even though I'm in a rush to develop this product and get it out there, there are some things I should be thinking about now. My husband happens to be an engineer, and he's emphasized to me that if you don't make a plan to dispose of electronic data, later on you're not going to be able to do it. It's just not going to be feasible. You're going to break something trying to get through your systems and delete the data that you don't need. You're going to mess something up. You need to have thought about it at the time you built your system and be in a position to dispose of it. And then I want to open this up because privacy by design is one of the most important concepts to see
Why don't we ask Lauren to comment?
Well, I think, privacy by design is a description of a type of a method of practicing within the company. So I guess, there's a way of thinking about a privacy policy as being just a description of a product. So you build the product or the service, and then afterwards you describe what it does in the policy. And I think what privacy by design really is about, like, flipping that process. So in some ways having the privacy policy be a roadmap for the building of the product. So thinking about the questions that you need to ask about collection and use from the start. And what do I mean by that? Well, so I work with a company that has like a smart thermostat. So the whole point is that, well, it knows if you're here or not, and therefore can adjust the temperature to suit you. Well, obviously, they need to know information about, you're moving about. That's the whole point of the product. So start from the premise of describing the product in that way. And then when you get to the description in the privacy policy about, what do we collect? Well, it's not surprising to anybody that you're collecting information about, how many people are in a house and at what times of the day. That's what the product is. And so I think like baking it in really means that, and I can give, tons of examples where you start from, I have another client there. It's like an application that's like a personal assistant. Well, a personal assistant is somebody who you give a lot of information to so that they can make your life better. So it's not about, you have this app and then afterwards you just describe, well, this connects to these different pieces of data that you have. It's starting from the beginning with, well, what is a personal assistant? A personal assistant is somebody who you tell where you're going to be and, who makes your travel plans for you. And this means that privacy becomes, it becomes part of like the product description, that purpose-driven collection. We're collecting this information to provide you with this service. And it becomes working with the marketing people because all the messaging about the product should include information about data collection and sharing. It includes working with the technology people. I mean, the problem that Laura just described, I get presented with all the time. If you don't tag data with the date of when it's entered into a database, well, you can't delete the data after a year. You need to start from the beginning with even choosing the database and making choices like, are you going to store data in the cloud or are you going to store data locally? Are you going to encrypt data, hash data? How is that going to affect the team's ability to access that for different purposes? Or what if, customer service? Like I said, I work with customer service a lot, and I try to push all my clients to have me work with customer service because these are the people that talk to the world, so they get asked questions. And what kind of authentication are you going to require in order for them to answer those questions? Maybe there's some things that you can reveal with less authentication. So I guess, privacy, I'm trying to describe a high-level concept by example, but privacy by design is asking all sorts of questions and asking them earlier in the process so that the people who are building it think about this as being a core part of the design of the process and not just something where, you're writing a legal document afterwards. And I think the real benefit for the company is that you don't get in a position where you're trying to hide things in the fine print. It becomes self-fulfilling that if the product was designed with these things in mind, then they become part of the marketing and the messaging and the sales and the description of the product, and then you're really you're highlighting these things in the privacy policy. I mean, privacy policy becomes part of the marketing of the product. So Yeah, I don't want to, I'm happy to answer more questions about how this comes up in specific instances, but I think it's also, it's a push for the person in the company who's in charge of privacy to be more engaged in all parts of the process so that privacy becomes something that everybody's thinking about.
I think it's often useful to discuss teachable moments, which are, often cases where a company has made a mistake and will be called to account for it. So I mentioned earlier, and Lauren and perhaps Marcia can jump in and give more examples of this, but I mentioned earlier a couple of data security cases that I'd give some examples. So let's talk about this to highlight, hey, what are some of the reasons when companies get caught in a position where they may have fallen short on what they promised their users or fallen short on their obligation to refrain from unfair conduct? What are some of the circumstances that lead to that, and how do you recognize those? So we've talked a little bit about data retention, and I mentioned earlier the BJ's case, which was a case where we alleged unfairness for failure to safeguard magged striped data in a credit card that made it really easy for hackers to come through, grab that data, and create new cards. So in that case, one of the things we always have in our data security cases, very useful to know if you want to just see kind of a list of the things that we think may fall below your legal obligations. We have this paragraph that we call the among other things paragraph. So we say that a company failed to take reasonable steps to protect security, and among other things and we list out the oopses. And one of them in BJ's was keeping this data, the mag stripe data, longer than they needed it. So if you don't have a business reason to get rid of your to retain the data, or you're not specifically, if you're specifically legally required or authorized to retain it, that is fine. If you have an obligation to keep your loan records or whatever other records, that's fine. But if you don't have a business reason otherwise to retain it, we're going to find that very, very interesting when we talk to you about your data security practices. Another challenge, so another kind of teachable moment, that's the data retention one. Another challenge is, companies tell me all the time that they just had to do something quickly and there wasn't time, that they engage in an iterative process and they build things through the evolution of their product and they have to get it out there. We find this less than compelling. We think that if your product if you haven't been thoughtful about privacy, your product isn't ready and you can't release it. Users expect it. They expect you to live up to your brand with the products that you launch and that you make available to them. So don't just think, for example, that you can market as a beta and fall short of the things that you promise that you do in your corporate practices. I'm going to pass it over to Lauren, and we'll come back to more of these.
Sorry, I just wanted to jump in because privacy by design does not mean that you have to have the most privacy radical choice for every element of what you might describe in a privacy policy. So for example, for data retention, let's say, if you're trying to track people based on a business cycle, you might have a different data retention policy if it's purchasing a car versus purchasing milk. So for purchasing a car, you might need to keep data longer. And it might make sense. If you are trying to notify your user about birthdays. Well, birthdays are only once a year, so keeping that data for 6 months or 7 months or 4 months or 3 months, none of that is useful because it's not going to be the purpose for which you're collecting the data. So that privacy by design is about having this conversation, which is tell me why you need this data. And tell me why it's going to be useful to you in the future. And let's think through what would make sense as a minimization, starting with the premise that we do want to minimize collecting, but also starting from the premise that as long as there's a business purpose for keeping the data longer, then that's a reasonable thing. And as long as you disclose that to the user, that's fine. That's probably what the user is going to expect. There are proceedings where I've been arguing for longer data retention than what people are offering, because I think it's going to be useful to the user to have that data for longer. So I guess in essence, privacy by design, to me, is really more about this conversation actually happening and there being some documentation of the conversation happening and why the decision was made. And without putting Laura on the spot, I think if you're ever in a position before regulators and you're able to say, well, at this point in the design process, we had this conversation and this is why we decided to make this decision, it's gonna, it's gonna put you in so much of a better posture, because, it doesn't just look like you did, the worst thing possible, but it looks like you made a choice for a reason.
And this may seem kind of obvious, but while privacy by design is extremely, extremely, extremely important, another very important thing is that your public representations, such as your privacy policy, accurately reflect what you do. And I know that sounds very basic, but I think that there are a lot of companies out there that basically will just copy and paste somebody else's privacy policy or terms of use and then just kind of use it wholesale. And I don't think anybody should feel like they have to reinvent the wheel, certainly, but I've seen a situation. There is a major internet company that shall remain nameless, but the first iteration of its privacy policy was stolen word for word from Flickr, the photo sharing site. And the reason that I know this is because it said Flickr throughout the privacy policy. And so, it makes you wonder, A, whether that privacy policy really reflected what that company was doing with users' data, or whether they just said, well, we got to have a privacy policy, so let's see what other people have done. That one looks good, let's just take that one. And this becomes important because, as Laura was mentioning earlier, you can get in trouble with the FTC for making deceptive claims to users, for making claims that don't accurately represent what you're doing. And so, again, I'm sorry if that's like super obvious, but
I think by the time you get into the law enforcement context, when you read our complaints, they often read like something like, wow, that is super obvious. But that's another great teachable moment, is the kind of cribbing things from other companies, which happens not just with privacy policies, but let's talk about something that might seem less obvious, and the code for how your app works or how your program works. It's quite appropriate. You don't want to reinvent the wheel every time you create something, but you might not know exactly the mechanics of what data is being collected, what's being shared, whether there are ad networks embedded in the app that you're using, and you need to know those kinds of things, because that if we see that you've made promises in your privacy policy, we don't share your information with anyone, but you have an ad network embedded in your product, we are going to see that as sharing. An ad network is not your organization; it's a third party. So you might think it's obvious. Don't cut and paste somebody else's privacy policy, but you're going to want to know what have examined, how your products work in the mechanical sense too.
And just from a practitioner standpoint, I don't think there's anything wrong with using somebody else's privacy policy as a starting point, but just make sure that it actually says what you mean it to say, and that it's readable and understandable. And there are some privacy policies that I think are better at this than others. For example, I think Twitter does a pretty good job of explaining its privacy practices in plain language that a normal person can read. And Google takes this approach where they actually have, your first interaction with their privacy policy is very kind of nuts and bolts. Here are the broad strokes. And if you want to learn more, click here, and here are all the details. And so that's another way that you can think about how you might want to do something like that.
So any questions about the privacy by design or the privacy disclosures? In the state of California, you're required to have a privacy policy, but it's not the only way, obviously, you communicate with your users about privacy. Yes?
You were saying that the FTC is unpersuaded that time constraints on product development are a good explanation for failing to meet customer expectations privacy-wise. I'm wondering how realistic that is, given the nature of product development, which is very often iterative, and you're kind of discovering user expectations as you go along.
Right. So, this is a good time to remind everyone, I'm speaking as a staff person, so I'm not representing the commission officially. This is not an official position. No, and I'm still going to address it, because obviously you kind of care when it's a staff person who contacts you in the first instance, and that's who you're dealing with. So you want to understand that kind of perspective. So that's just not the whole story. We want to basically see, or what I think is I want to see that you've thought about privacy equally among your concerns. It is part of your product. It's part of what you're offering. You're not thinking about, your marketing and your timeline and your other concerns at a disproportionate level compared to privacy. So it's not that we don't recognize that other concerns exist. Of course we see that you have business concerns, and the privacy choices and design that we expect are reasonable. If you say to us, but that's not feasible for us, that design choice wouldn't work for us, that we find perfectly, that's legitimate. But if you say, we were in a real hurry to get this out by April 1st, so we couldn't deal with disposal then, or we couldn't check to make sure our statements were accurate then, or we couldn't put rate limits on the passwords for our website because we were in a rush. If you fail to take really basic measures and you simply cite your time constraints, that's really the kind of thing I had in mind. So it certainly doesn't, saying that you had business concerns isn't going to make us say, oh, okay. No, that's a very important point. That's a good thing to clarify. Yes. Right.
And you would want to actually have a policy that enabled you to share some information with law enforcement and law enforcement people around the world. What kinds of things would you be thinking about?
It's interesting. So we have had...
Did everyone hear the question?
I believe the question is about if you are operating a consumer-oriented service to protect consumers from, I don't know if it's identity theft or protect them from malware. What kinds of policies would you want to have about sharing their information with police or something like that?
Sometimes you do have information about when a virus gets started, you can help track it, things of that sort. And you periodically get requests from
Right.
enforcement people in the U.S. and outside.
Yeah. And I will let the folks who give advice to private companies jump in here for that. I mean, from our perspective, a legitimate basis for disclosure is sharing with law enforcement or sharing for the purpose of fraud prevention. So the disclosures, we have, had some cases where we alleged that companies that promised to protect consumers' information or to limit its exposure online, that those companies were not delivering the service they promised. So we've had a couple Section 5 cases there, but this is really a separate issue. Like, when you're delivering the service, when can you share consumers' information with law enforcement for fraud or crime prevention reasons?
So I think the first thing you would want to do is figure out whether your business and the type of information you collect is governed by the Electronic Communications Privacy Act, which is this law that governs how businesses that provide electronic communication services or remote computing services can share data not only with law enforcement but with private parties as well. And depending on the type of service you provide and the type of data that you would want to share, that might be governed by that law.
Where in some cases they would want to enable like a specific law enforcement actor who's acting on behalf of their customer to investigate a crime. And so it does become interesting to figure out how to do this. And sometimes in this particular case, it became a question, so if somebody's stolen a mobile device and you're trying to track that person, well, how would you do that in a way that doesn't notify the person who's stolen it that you're trying to track them? In the same vein, you would want to make the user, if they were the ones in possession of the device, you wouldn't want to allow them to be tracked unnoticed. So like there's different things in the design. But I think that's a hard question. And in some businesses, there are legitimate sharing purposes. And for me, I think a lot of there would be, if you are going to be sharing, then to be heavy on the notice. So, you know, I have clients who like are hypersensitive about being like very forward about notice about what's collected and when it could be shared. If you're using a technology that's like a privacy-enhancing technology or any sort of technology where somebody might be using it in order to gain more privacy, then you want to be super explicit about the downsides of the technology, just so that you're not promising something that people are erroneously relying on.
Before we move and sort of talk about these choice mechanisms that Lauren has now raised, you should use to engage your users about your sharing practices. That's a great segue, and that's in fact what we're going to talk about next. I just wanted to highlight, so at the beginning, Susan showed a slide that she said was where you could go to get information about the FTC's business guidance. That website, the URL didn't show up on the slide. It's just business.ftc.gov, and it has case highlights, and it's searchable. And you're welcome to contact me with questions, Berger@ftc.gov. So just wanted to throw that out there. But one of the guidance pieces you can find on that website is one that we very recently put out, and I'm happy to say we got very positive feedback on it. It's called Marketing Your Mobile App, A Guide for Business. And it just gives you your kind of like top line. I think it succeeded in giving a little bit of information that would be thought-provoking and help you apply the guidance to your business. But one of the things that it says in here that I think is very relevant to the discussion we've been having is, hey, do you think you don't make any promises about privacy? Think again. So you don't just have your privacy policy, you have the way your website looks and feels to your users and things like privacy settings that are also, we would often say, making promises to users about what your practices are going to be. So let's talk about choice. So privacy by design was one of the key principles of this privacy framework, and simplified choice is the second pillar, and then we'll talk about transparency as we're winding up. So simplified choice is recommending that you provide easy-to-use choice mechanisms to let users control how their data is collected, used, and shared. And we talked in this about notice in context, and that's exactly kind of the thing Lauren was starting to highlight. You don't just want to have a privacy policy that spells out what your practices are. You want to give users options, and you want to do this. The privacy framework has a discussion about this, and this is something I hear a lot these days. You want to give notice in context so that the user can make a choice, especially on a mobile device. You don't want users to be trying to navigate through long dialogues or a lot of text while they're trying to, like, hey, can this app access your location data? To make a restaurant recommendation, we need your location. You want the user to make that choice when they're in the context where they want the service. So you should be thinking about these easy-to-use choice mechanisms. We spelled out in the framework that you don't need to provide choice for practices that are consistent with the context of the transaction or the context of your relationship with the consumer. You want to think carefully about what those are and continue to think about your business and your operations from the perspective of a user. So, it's not going to be consistent with the transaction just because everybody in the industry does it. It's consistent with the transaction because a reasonable user would expect it to be. So if they've ordered a product and they want it shipped to them, it's quite consistent with the transaction that you would be sharing their information with the shipping company. And then for practices where there is choice, as I mentioned, you should offer it at a time and in a context where the consumer's thinking about it. We also spelled out a need to get heightened consent in some circumstances, and these are really key to think about. It's where you're using consumer data in a materially different manner, using it for something different from what you claimed, or collecting sensitive data for certain purposes. And you'll have this in your slide deck. Do not be disquieted by the slide disappearing. So I don't know if Lauren has real life examples about companies trying to do this kind of choice.
Yeah. Well, I think this is sort of where the game is at now with privacy in terms of trying to figure out how how to contextualize it, how to make these choices more salient for users. For example, if you deal in the world of apps, a lot of people, they hear about an app, they want to download it, they want to try it out. They'll flip through whatever onboarding process you have in order to get to it so that they can use it, so that they could see if it's something that's going to be useful to them. And, so if you have all these great disclosures in the process of signing up, whether you do it in a not so great function as like 7 pages of block text that's uninteresting, or even if you do it in a sort of, layered, bullety approach, it's still like people want to get to the app to see if it's going to be useful, because that sort of is the point. Like that that's the point of purpose-driven collection. The app is taking your data, they're going to provide you with some sort of service, or there's some purpose for it, and until you engage with that purpose, you don't know whether it's going to be useful to you. So it might be the case that at that point, if somebody decides they don't want to use it, you make it pretty easy for them to delete and get out of there. And that might be more important than the disclosures you had at the beginning, or you might want to increase disclosures throughout their use. So maybe on the 10th use of some function, you then remind them about, we're collecting this data for this purpose. So I think this whole mechanism to try to figure out how to make the choices about what the information about what the app's doing relevant at some point that the user's ready to think about it is really important. And just sort of getting to throwing in for the ethics component, this is something that I deal with a lot with my companies, where how much notice do you want to provide? And there's a lot of interest in notifying users about things, but some pushback about interfering with the process of obtaining new users. And anybody who deals with in the technology field, this is like a big issue. And so it becomes sort of a conversation, how much do I, as their lawyer, want to keep pushing them for more disclosures, clearer disclosures, more opt-ins, where their goal, the growth team's goal is to make as many people sign up as quickly as possible. So it is a process, and this is where I found that some of these ideas about, maybe you automatically create a user account when the user does some sort of meaningful interaction with you, but then you remind them of it, 10 clicks later. So ways to try to think creatively about how you can still support the goals of the business overall, and have respect for the users to understand what it is that they're signing on for. And it is my belief, from doing this for a long time, that if it's a good value proposition, users will share their information. Realistically, and I come to this with like a background of advocacy and academia, and the truth is, like, users are willing to share information if they find value in it. So, I don't think you're have to be forced in a position of selling the company on something that is bad for the business by providing notice. So it's just being more creative and more relevant in terms of how you provide it. And sometimes it's caused me to think about this, where I have like one client where I've been pushing them to provide a lot of notice, and I know that their competitors provide no notice. And then my client is now more in front of the privacy issues than their competitors, because people know what they're doing. And so notice does brings some baggage with it. But, at the end of the day, belief in, respect users, respect the process, believe that, providing more notice is going to make people more comfortable with your product, and that's going to create trust, and it's going to make them more willing to disclose and more willing to trust you than a competitor who somehow later they find out is doing something that they didn't expect. So, but it is a balance, and I find for me, and the reason that I do this as basically a solo is that I go into my companies, and I work with a lot of very small companies, and I get to sit with the CEO and the CTO and the chief of marketing, and ask them 100 questions about how the business works. And I ask almost the first question I ask is, how are you going to make money? Is this a data business, or are you selling a product? What is it? How are you going to make money now? How are you going to make money in the long run? Because these are things that I think influence what I consider to be the DNA of the company on privacy, and it allows me to counsel them in a risk management way that measures the sort of, understands where they're going, and then when I push back on them from the user perspective, I have a better understanding of what the product is. And again, it's not just describing the product in some sort of legal document afterwards, but being part of the process throughout it.
Yeah, I was going to ask Marcia to comment. My question for Marcia would be, as you take a public position, advice towards consumers, advice towards public institutions, for example, like libraries or universities. Mm-hmm. How does Electronic Frontier get involved in creating public discourse?
Well, we do what we can to try to make sure that users have a voice. We are a membership organization, and our members are users. And we have an activism team, and one of the things that they do is they, at times when we feel there's an opportunity, like there's pending legislation, for example, we try to give users a voice to make sure that they can, convey to legislators what they want. And I think that we've seen some instances in the past year or so where there have been these opportunities where legislation has been pending in Congress that would, really start to impinge upon free speech on the internet, for example, or expand intellectual property rights in a way that we worry might impinge on people's fair use rights or free speech rights, where there's been this tremendous kind of groundswell from users that has really helped to beat back those proposals. And I think it's a very interesting time to be working on issues like this, because I feel like 10 years ago, many of us used the internet, but there was still sort of this public perception that the internet was something that wonky, techie people used. And, regular people used it to some extent, but didn't really understand how it worked that well, didn't really care how it was going to develop so much. But I think that the vast majority of people now use it a lot and really care about how it develops. And I think that there are tremendous opportunities for the public to be involved in the discourse in ways that just really didn't exist before, and to really have an impact.
Over to
you. We're talking about a lot of different things about the development of the internet and the development of your company's practices too. And I think this next issue, so we've talked about privacy by design and we've talked about simplified choice. We have not really had a chance to talk about one of the components of simplified choice, which is do not track. And that is one of these kind of like internet-wide policy discussions. I will say 2 words about it just so you kind of feel like we touched on it, but this is something advising an individual company you're likely not as responsible for. It was a policy call we made upon private industry to develop a universal, persistent, and effective way to opt out of tracking for behavioral advertising. How many of you guys know what that is? So like I would suspect in this audience almost everybody. So when an ad network or third party is present on lots and lots of sites across the internet, they they use cookies and other locally stored objects to get a pretty clear idea of what individuals' browsing activities are, and know that you're looking to buy, a plane ticket to go to New York in a couple of weeks, or know that you're looking to do some renovations on your house. And then these ad networks can help ensure that when you're later reading the Washington Post, you happen to see ads to, hey, do work on your house or buy a ticket to New York. And many users find this very useful and beneficial, but not all users want to be tracked during their browsing, and we recommend that users have a choice. And we called upon the browsers to develop choice mechanisms in the browser header that would express a consumer's desire to not be tracked, and that all parties, websites that they visited and others would respect the choices expressed through the browsers. And just something interesting for you to know, all the browsers have come up with these choice mechanisms, and folks are working now on exactly what the implementation of these would be. Many people have, browser companies and others have highlighted that when given choices, rather than choosing to completely opt out of tracking, consumers will tailor the kinds of ads they want to receive. So it's still very kind of early stages for the implementation of this, but it's something a lot of people are looking at and talking about now in the choice context. So just to turn to the third pillar, and we can take questions at any time. I know we're getting short on time here, but the third kind of pillar of our privacy framework is really this kind of broader issue of transparency. You want to communicate with users effectively about what's happening with their data. Obviously, with your individual site and your individual company, you want your privacy notices and your descriptions to be shorter and clearer. We recognize you have a lot of demands on you, because if you operate in California, you have to have a full privacy notice that does describe everything in a lot of detail. That's the law. But you also want to be transparent with users. You want to find effective short ways to communicate with them in some of the ways that we've been talking about. And we've really urged companies to do something they've been very effective at doing in a lot of other instances, which is to develop standardized icons and symbols to communicate so that users can more effectively and easily understand. And we've seen a lot of interesting activity in that area too. There have been, icons that you can click on, the eye icon, to understand why you're seeing a particular ad. So that we expect to see a lot more developments and innovation in that area too.
I think we'd like to take some questions from the audience now. Yes?
Can you give us a little bit of insight on how these various companies get on the radar screen?
Yeah.
We all read about,
Yeah.
we all read about these big cases.
Yep.
It can go both ways. Either somebody doesn't want to get on your screen. In a lot of cases, people ask, how do we get on the FTC screen?
Mm-hmm.
How somebody who's abusing one of these things. Can you just give us a better understanding about how that works internally there?
Right. So first of all, as many of you might imagine, many more companies are sort of on our radar screen than you'll ever hear about publicly. Very, very often we get in touch with a company and say, hey, we have some concerns. We see that you're promising to do A, B, and C, and we just want to understand exactly how do you deliver that. But after getting further information, we're satisfied. But the cases obviously that you hear about, all of our investigations are non-public, so the ones that you hear about are the ones that proceeded to a stage where we wanted to allege law violations. And the way that companies come to our attention, there are many, many ways. There are a lot of privacy advocates out there who are actually very useful to us. They want to point out to us, and they're often very quick at doing it, because their job is just to bring to light. They're not developing legal proof that would necessarily hold up down the line in a case, but they will highlight a concern, and we pay attention to those privacy advocates and researchers. You could have seen in a couple of cases that we did, one of the claims in Facebook, one of the 8 claims in Facebook, and then in the MySpace case, we alleged that when users were clicking on ads on these social networking sites, information about them that identified them, which user they are, was being transmitted to the advertiser through the referrer header. And that was highlighted by a lot of researchers, that kind of behavior. So that behavior became something that folks were interested in looking for. We also do research on our own, and we have in-house technologists. We had our first chief technologist for the agency was Ed Felton. He continues to represent us in the do not track discussions in the broader community. And we have other in-house technologists now, and we have sometimes staff technologists who help us. Folks also just, do it the old-fashioned way, setting there. You have certain companies you think are pretty important. You set your Google alerts and you read about whatever anybody's writing about them on the internet. So really all kinds of ways. Also, the state breach notification laws have given us a pretty rich potential target list. When companies are required to send out notices, like 46 of the states have data breach laws requiring that you, under some circumstances, send out notices when you've had a data breach, and we pay attention to those too. So lots and lots of different ways. Anything else?
Questions? Yes.
A little off topic, but I'll ask anyway. Due to the increased emphasis on privacy, security, and the international aspect of applications, and I'm in the technology field, the proliferation of encryption is everywhere, and yet it seems to be contrary to the whole notion of having to get an export license for everything you export. So have any of you been exposed to the balance between applying encryption to everything and the fact that you technically have to get an export license everywhere? And how do you manage that?
Yeah, I am afraid I cannot comment on the export license issue. The question is, when you have an obligation to do encryption, how do you balance that against the need to get export licenses? And that is not something anyone has raised with me before, so
I would just say, as a historical matter, encryption is sort of a sensitive topic because, there are people in government who are very seriously concerned with the use of it by other people. And I think that, getting an export license is a compliance issue, and it's just something that you is a process you have to go through. That's true, and I think, it's one of these things like where there's a very concentrated group of people who are very concerned about the risk, and therefore everybody else has to bear the compliance burden. So, but it's just something you do. I don't see that going away ever, if that's...
Yes.
Okay, so the question is, how does the privacy jurisdiction that we've exercised under Section 5 mesh or overlap with other privacy laws? And the example given here was HIPAA in particular. So let me just say that historically there are a lot of privacy laws that are sectoral, meaning they apply to a certain type of user, such as kids, the COPPA law, or they apply to a certain type of decision or use, like the Fair Credit Reporting Act, which applies to these eligibility determinations and uses, or they apply to a particular type of data, like HIPAA, or the Gramm-Leach-Bliley Act, which applies to financial information. And the bottom line for HIPAA in particular, the FTC has jurisdiction over some health information entities, and HHS, the Health and Human Services, has jurisdiction over most of the relevant entities. But what we've done with all of our sectoral laws and our Section 5 authority is we've really made them very consistent. So I believe, my perspective is we've really tried not to, where a law stops short and has a clear limit to its obligations, we haven't really tried to use Section 5 to bolster an existing more specific law. We've really tried to give recognition to, if a company demonstrates its compliance with an existing law that's specific to your sector or your information, you're going to very likely be good under Section 5 too. So we've really sought, and I think you'll see in our cases, often when you violate one, you'll violate others that apply to you. But we aren't coming in where you have complied with your, concrete sectoral law and saying, oh, but you violated Section 5 for those same facts, even though you complied with HIPAA.
Any other questions? Yes?
Sure. I have a question about Do Not Track and the fact that Do Not Track is being pointed at the browser makers when really the browsers are not collecting the information.
Right,
The
absolutely.
browser trends
Yep.
are a means of access.
That's right. You're right. Yeah.
I'm wondering is that the right choke point
Yep.
when the browser has no ability to
Yeah.
affect the
Yeah.
data collection
Yeah.
practices
So,
of the other
yeah, here's so the question is, what's up with singling out the browsers to implement this do not track solution? And I think why them when they're not the ones collecting it? Why not say, hey, Mr. Ad Network, you're responsible for this? And I think the answer is that the browsers were an effective and universal choke point. So when you access the internet, you're doing it through a browser, and they can, if you did it through something like a cookie that said you don't want to be tracked, obviously when you delete your cookies, that's not going to be persistent. You're going to delete it. So we just wanted to have something that would be universal and cover all of a user's browsing activities. Again, this is a policy recommendation. There's not a law around do not track. But the enforcement would be against people who violated it. So, if somebody has a stated preference of do not track, there's potential for them to be deceiving users if they're not honoring that. We'd have to make it fit under Section 5. So.
Yeah, there's a question in the I've been following this issue for a while, and there's a question about what the disclosures that the companies are going to have to make. So if you say I comply with the FTC specification, then that can be seen as a promise that you're making that can be enforced under Section 5 the way that other promises can be enforced. So I think at the end of the day, the browsers are trying to have as little compliance obligations, besides providing the choice mechanism to the user and leaving it to the networks are going to be the ones that are going to have to make promises.
Sure. So the browser has something similar to a CDA 230 to be able to say, I gave the flag. If someone else violates the flag, it's not on me. If I say there's a flag and I don't give
All right, we have to go.
Yeah.
Right.
So the browsers are gonna just do what they want to do anyway.
But most likely for it to be an enforceable piece of conduct, there'd have to be some kind of promise in all likelihood. So you'd have to, through your trade association, a lot of trade associations are saying we expect our members to honor do not track preferences. And so by being a member of that trade association that makes that recommendation, we could potentially say, hey, you promised you would do this by being a member and posting your membership seal on your site.
So I have to say we're out of time, and I do want to release people who need coffee or whatever. Let me just first of all thank our panelists. I've enjoyed our presentation, and I hope you have too. I understand there was a problem with transmittal of this complete set of slides, so I'm putting a sign-up sheet here. If you put your email address, and I won't use it for any other purpose, I will, when I get back to my office, email you the PowerPoint if you want to hear it, receive it. So I think it will be available at the State Bar, but if people actually needed it, wanted it before, I'm happy to do that. And I just want to thank Laura, Lauren, and Marcia for participating today. Thank you so much.